Greetings and salutations.
Bueller. Commonwealth motion to enforce compliance with court's April 16th ACA discovery order, and the Commonwealth's motion to preclude new expert testimony, or alternatively to continue the trial date. That those motions will take a little bit of time, Mr. Brennan.
I don't think in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No.
All right. In light of that and the fact that we don't have time, this juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ACA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
On that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson's going to give you the facts. I would like to hear the law.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Eyes, please. You are muted. You are unmuted.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
2282 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time. And we do appreciate that you are all here, ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please? Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God? Yes. Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors, hearken to the evidence.
All right, thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, Keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement. Then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently. It's also my instruction to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day, and they'll be locked up, and they will remain confidential, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath that you've just taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Thank you, Your Honor. 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe. He looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words through firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information that was useless to him, he continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, "I hit him, oh my God, I hit him." And then she was interviewed, or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, her first responder, I did. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant and her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited 2 minutes. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded, yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together. They did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension. There was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave, but she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022. You will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping, moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Okay. And the third thing, remarkably, will be an expert in this case, who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrive at 8:50, they stay till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours. That's consumed. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, or there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're gonna go back to 34 Fairview Road, what we talked about earlier. They're gonna go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, we'll be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, is somebody that John had dated before this. And so as they make their way through Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop and then they do a 3-point turn in the driveway. You see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important. That's 7 minutes before the road. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second, stop, go very slowly, all the way to the end of the yard, in the corner, where there's a tree line and flagpole, and they reach that location at 12:34:33, and they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe, park behind us in the driveway. 12:29, she texts again, are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. You will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message from Jen McCabe. There's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that. And at that time, 12:32:09, last user, he has 7 more seconds to move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently than 30-second variance, but it's right in the heart of that time. And you will see through the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tires spinning right towards him. Right when he got out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moment of the fight. She drives away. And they said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he was just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. So 77 degrees in the one car. Now that he's been outside the car for 5 minutes, drops to 72 degrees. She drives to his house. She makes a phone call at 12:33 after she's left there. She calls again at 12:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. Pardon my language. You will hear the simmering. And she leaves that message. She lies on the side of the road. He gets another text message that's unanswered. Where are you? 12:45. Battery temperature, 61 degrees. So he gets almost 40 calls from the defendant that night. His phone rings, but he never answers. You'll hear from an expert that the light never initiates, the healthcare data never holds. John, alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her. But her message, you'll learn the message says, John, nobody knows where you are. And this is where the plot in the cover-up begins. The evidence will make clear that she knew he was there. But she did not call 911. She did not go back to him. She did not leave an anonymous note. She left. The night wears on.
It's because she didn't hit him.
It's now 107. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. And you'll later learn that she admits to falling asleep fast now. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount out of the deep sleep. She wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls back. And then she, what's going on? And she told, well, I left him at the waterfall. At the beginning of the cover. She told Jen McCabe, I left him at the waterfall. Jen called back and says, you saw you up front. You did leave him at the waterfall. She hangs up. He then minutes later calls another person, Kerry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a fly. I think he's dead. Now, Kerry, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned. Not him. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Kerry Roberts, the other friend, then goes to Jen McCabe's house, pulled behind the car. And when she does, she's on Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Kerry Roberts takes over and says, we're gonna go back to John's house. Maybe he's in the house when you didn't see him. So both cars, driven by Kerry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Kerry, enlisted into this task. Look for John O'Keefe, they cannot find him. And then when Kerry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they gotta go back to Fairview Road. They decide to take one car, Carrie Roberts is taking charge, she's gonna drive. They leave Miss Reed's Lexus and John Keith's driveway, and they drive back towards 34th Fairview Road. There it is blizzard-like conditions. It is dark, they can barely see a thing. And when they get close to the edge of 34th Fairview, you hear the defendant start to scream, "There he is!" Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, "Let me out." Carrie Roberts stops the car and lets her out, and she sees the defendant flying.
Happy Toots Day.
Where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes one of her best friends in the world is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jim McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shut down to 37 degrees, Carrie Roberts picks it up and puts it in her pocket, and it immediately starts to warm as she moves to help get data, showing movement starts again.
I assure you the jurors are already asleep.
At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar in his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then Carrie Roberts goes and picks up Peggy O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Carrie Roberts is walking. Peggy O'Keefe is going to go see her son, with her husband. And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her into evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you hear that Karen was excited and yelling, "Is he dead?" Stops her excitement. He becomes stoic. He doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see on the dash cam video, this dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend had taken them, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, no condolences to Peggy. And they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs, they're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, who drove his wife and the father from that house. But when they leave, they take two cars. They take the Lexus with the broken tail light with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken tail light, they learn learn information that
They
she had
turned it
told
up.
people that she had hit him. They went down to see her. And on their way down, they decided they would get a foreign take Lexus. When they get down to Dayton, where the car is, you'll hear from Trooper Buchanan. He took a look and you can see the missing shell. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug the excavations, they found his shoe on a little berm on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his hat frozen to the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all.
Real quick, guys. Hey, good morning, everybody. Welcome to the Morning Mayhem Show. I am Sam. We're going to be covering the Karen Reed trial. Just real quick, do you guys know what it would take to smash a taillight into pieces? Not a human body. I just want to say that.
Every piece of that broken taillight in that area had the sneaker, the glass. When the defendant left Mr. O'Keefe behind, took with her something of Mr. O'Keefe called trace evidence.
Check.
You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor and neurosurgeon who's treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, on the cracked skull, it's called a basal fracture. It created an injury called counter coup. After he was clipped by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing.
It wasn't me.
And this neurosurgeon will tell you, he treated thousands of patients, that this injury, with reasonable degree of medical certainty, is counter coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it as undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction.
That will say whatever we want.
Does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck Ron O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, bringing to kill, deliberate premeditation. Your Honor will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act, which would cause a plain, strong likelihood of death. That's what we'll prove to you, second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left them behind. And died. That's the whole group. This case will come down to the science and the data. The science and the data, the cell phone is the best of historians. It doesn't suffer from intoxication, it doesn't suffer from memory loss, it doesn't suffer from emotion, pride, or prejudice. It is facts, it is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign to make public statements. 2020, Nightline, Fox 25,
Yeah, defending herself.
a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and data, what you will already conclude from the facts independent about what she did that night. Her word simply confirm that your judgment is sound. And you're going to hear from her own lips and many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Alexis, her admissions to being angry at dawn that night. And I dare say her admissions that she told. I'd like to play for you.
Thank you, sir, for becoming a new member. I appreciate it.
Statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
She's speaking after the fact. That's not her saying what happened there. Nice try, Buster.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29th, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but then who helped? A lifetime of help was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Right.
Could I have just a moment to?
Showtime.
Sure, the court officers will be kind enough to help you.
I mean, this is the only guy we really want to hear.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period.
Nope.
The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer.
Ooh, that didn't take
named
long.
Michael Proctor.
That didn't take long at all.
He was the lead investigator on this case. And he was talking about a fellow officer, a fellow cop who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start, corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn.
Crazy, huh?
More shockingly,
So
you'll
crazy.
learn that lead investigator for the Massachusetts Police, Michael Proctor, never set foot inside Brian Albert's house that day.
Wow, right?
Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. I suspect that was probably by design. But make no mistake about it, the evidence will show in this Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty, doing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. For one reason and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that Michael Proctor's rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian and his friends. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up.
Where they
When they got
planned
to
a
the Waterfall Bar
murder.
and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the Waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier, she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls them names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. Laposado will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. Laposada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her, but she was gone. Dr. Laposada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. Laposada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt. But there's much
Yes,
more.
it was crazy.
We'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been had he actually been there right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth. And he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did. And we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here, a collision. And there's no evidence of one, zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds.
Hey, Nova.
Had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn, Brian Albert got rid of. Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations. He literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone. Long to die in cold hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own.
So crazy, man.
The evidence, meantime,
So much is
Karen
wrong with
dozed in
this.
and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none. But they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor.
I didn't think they were
control.
going to be
And
allowed
he'll
to bring
tell
that
you
in.
That he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered.
So I didn't think they were going to be allowed to bring in the Sallyport video of the SUV in custody in the Sallyport evidence garage, which shows Proctor messing around with the taillight, and then half hour later they start finding pieces of that taillight all over the yard, even after everything. They'd already searched it like 3 times. All the officers, all the things, right? So maybe he's just allowed to talk about it, but not show the video. I'm not sure, but we'll see.
And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself.
Kimster.
It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He'd gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling. Oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about.
Obviously.
Your job will be to make sure that the evidence isn't presented to you.
Look, it's situations like that, and sorry to keep interrupting him, but it's situations like that that will because the jury's not dumb, that will make that jury just think that every single thing that comes out of the prosecution's mouth is a lie for presenting that as evidence, like that she was making a statement of what she had seen at 12:30 when really it was after the fact, because he didn't play that whole video, but I assure you Jackson's going to play it. And now the jury's just going to be like, dude, this prosecutor, they've already won. Everything we're seeing now, this whole trial, the next 6 weeks, possible, is all just for entertainment, I guess.
Too cute by half.
Ooh, too cute by half. I haven't heard that saying in a while. Not since the
She
Murdaugh
was saying all
trial.
those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened.
Same.
The evidence
grateful.
will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. And remember, Chris Albert,
He
the
would
other
have
brother,
him do it, so it wasn't
is
attached.
a
But
board
same
selectman
last name.
to whom the Canton
Idiots.
Police Department reports.
Idiots, man.
And what's more, you'll learn that Katie McLaughlin,
Hey,
that's the
Sharona.
EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years long, close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, along with Karen Reed's phone, along with John's phone, along with video footage, along with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants. He lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero. Nothing.
Something to do with
nothing
my
around John's
arm.
body. Nothing in the street. Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. Came up with zero.
You would think the Blue Line Gang would have learned after Mark Furman and the OJ trial, like that was a lesson of in what not to do in a murder investigation is to plant evidence, to be deceitful. I mean, I guess the list could go on and on if I'd had my coffee yet, but yeah, it's unbelievable. It's just unbelievable. I would love for justice to be to always have her blinders on and to have integrity, and it would be a safer, more comfortable institution. I think and everything I've ever done in trials that I've been in, I was always guilty. I was just trying to, get, a lesser sentence because there was things that I wasn't guilty of that, but, there was never any corruption. Only one time did an officer, actually it was a DEA agent. He was sent for retraining because of my case. Because he did lie a little bit, but it wasn't anything major. It wasn't like any kind of big, corruption in my investigation. But anyways.
To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead.
Crazy, right?
The DNA that was actually found, the actual science will show it was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt.
Guess why she won't do it? Guess. Because she knows. She knows it's a big cover up, scandal, corruption, and because it doesn't, she knows it's not a homicide by vehicle or whatever. And she is covering her ass that when it all does come out, that she can just say, yeah, that's why my ruling was what it was. Does that make sense? That might have been a little convoluted.
Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden.
All the butt dials.
Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing.
Mm-mm.
They're not going to be able to do that.
I really love
this
this guy,
handled
man.
by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the house and the utter lack of investigation speaks volumes about those who actually have something to hide.
Oh, yeah. Just wait, Grateful.
By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
There you go, bud. End it right
Thank you,
there.
Mr. Jackson. Folks, why don't we take our morning recess?
Court order, please.
Yeah, he destroyed that. He's a beast, man. He really is a beast. Hey, good morning again, guys. I am Sam. This is the Morning Mayhem Show. We are watching the Karen Reed trial live. That was the opening statements. Sorry I couldn't be here from the beginning, but I thought I would just go ahead and play it. Just a last minute thought. I did have a program I scheduled I was going to do today. This morning, had the trial not started. I was going to do a show on what Carmelo Anthony has in store for him when he gets to prison. it's not going to be a pleasant thing for him. And I wanted to do an entire show on why that is going to be. I mean, there's lots of people that have killed people that are walking around in prison with their heads held high, and getting slapped on the back. But I just want to do a show on why in Texas, in that milieu, MILIEU, he's gonna have trouble. So I'm gonna do that show probably later today. I do have a few tattoos to do today. So we'll watch the trial as long as I can, and do some commentary on it. I'm just super excited for this. But like I said, it's we already know what the outcome is. It would be a lot. I'm about to like speak like Tarzan. More fun, a lot more fun. That doesn't even sound right. If we didn't really know, what the outcome's going to be, but I assure you, after all my years of experience with trials and legal wranglings and all the behind the scene things, that this one is gonna be with an acquittal. I can't believe she didn't get it last time, but who knows what happened. But anyways, now with Proctor being fired, it's so much. And they have a lawyer that was on the jury. So there's a juror from the last trial that's now one of the defense's lawyers. He had to be on the team. He just had to after being a juror in the first trial. I think that's amazing. And with Proctor being fired for his conduct during the investigation on the last one, all these things, it's pretty cool. So anyways, we're just gonna just chit chat for a little bit. How's everyone doing this morning? Seen a few new people here in the chat. Nova, how are you? Welcome to the show. It's so good to have you here. Who else was new? Seen someone else new. Let me just back up. Hey, Sharona, how are you doing today? A lot of people that haven't been here for a while too. Come and Sam, ever try Vicks Vapor Rub for aches, etc.? Yes, and I just can't stand the heat, like Bengay Vapor Rub, like the mentholatum. I can't stand that feeling on my skin. I wish I could because I have a lot of muscle pains, nerves, sciatica, all the things. My lumbar injections are wearing off, so I got to go back for my hip injections pretty soon. Oh my God, I sound so old, man. Years of tattooing, years of skateboarding is all just coming crashing down on me now that I'm approaching 60. 60? What? Yeah. Physically, I feel like 60 is the new 70. Mentally, I feel like 60 is the new 30. I really do. I think some people back me up on that. Happy Tuesday, everybody. Hey, there he is. High as F. Look how high he is in that picture. Look at all the pictures you see of him and all the videos you see of him. Hours and hours where he's like kind of bright-eyed, and then there's all the videos of him looking like that. That's a good juice thumbnail right there. That is not edited. That is not AI. Don't let anyone tell you different. Yowzers. Zoinks. Scoobs. How many of you guys thought I was going to be late? I see it was about 30% on each option. Yes, I'll be on time. No, I won't be there, and doubtful. It was 30, 30, 30. It was. I have proof. Look at there. Look at that. Do you think Sam will make it by 8:30? Hell yeah. No effing way. Doubtful. So yeah, it was 30% on each. All the doubtfuls were like just kind of, playing it safe, hedging their bets. Pretty funny. But yeah, I'm hoping this is a good trial to watch, but like I said, I already know the outcome. So yeah, I feel like it is going to be a little bit boring for me to watch. But it'll be fun just doing the commentary. If it wasn't for my commentary that I'm looking forward to doing, I probably wouldn't cover it. Like just to watch it. And hey, Perfectitis, how are you today? It's good to see you. So glad you're here. Thanks, Caddy. Caddy, Connie, and Loudmouth Linda. Just counting on me. I didn't care. I was late too. Yeah, that's right. A proud no effing way voter. I knew you would be, Ben. I knew you would be. Don't go changing. Don't change for me. Just hate and discontent. Yeah, I really can't wait to do the Carmelo Anthony show. Yeah, I have lots of good intel. That's right. I said it. Intel. Lots of good intel from down at that neck of the woods. Real intel, not AI, or fake intel like the MDC guard video. No, that is a thing of the past. I was tricked, I tell you. I was tricked. I put the screws to him, see? Show me. Yeah. Yeah, where's my letter, buddy? Oh yes, LMPO. Also, I'm doing a show tonight on My Other's Keeper, and we're going to talk about tattooing and Christianity. I have a lot to say about that. Being a tattoo artist who reveals God's character, I do have a lot to say about tattooing and being a Christian. So that should be a really good show. Really looking forward to that. I'm going to be exhausted though, so that does suck because I'll have been tattooing almost all day, and I've been up pretty early. I fell asleep in my chair last night in this chair I'm sitting in. I fell asleep with my head like that, trying to watch something for something I'm like truly deep diving, and I fell asleep watching videos on it last night. And I tattooed till like 11 o'clock. So it was crazy. Do we have any milestones, recovery milestones today? Any birthdays? Anybody got 3 months, 60 days, 90 days, 6 months, a year, 3 years, 5 years? I'll wait. Sam Chit, I am here supporting After the Bars with like chatting and watch hours. I have it on and chat when I can, but doing tons of work before going out of town at the end of the week. Oh, I really appreciate that. Thank you so much, Perfectitis. I really do. I really appreciate that. I really need to get work on doing some campaigns to get more subscribers and viewers, and well, at least views, more eyes just watching each video. Even my legal channel is like I'm not getting the 30,000, 70,000, 100,000 views like I was getting because I stepped away from it to build this channel, but that's okay. It's all going to come out in the end. I just have to be patient. I am really impatient. Yeah, that is true, Kim. I do know that. Nicole on vacay? I don't think so. Should we just watch this fan spinning? Boy, look at he go. I should just do hey Woofy. I should just do thank you, Kathleen Menzies. Yeah, I know. I just gotta just keep doing it and just get me, make it better, be more succinct, get lots of sleep so I can be a better speaker in the mornings and things like that. But I do appreciate it. Hey, Cliff Ann. Cliff Ann, Miss Ferguson. The channel is Legal Livewire Court TV. No, Legal Livewire Court Watch. Now I forgot the name of it. Legal Livewire Court Watch. Yes. Well, because it was All Rise Legal Network, and I changed it to Legal Livewire. So, and then it was Court Watch TV, and I think I took off the TV at the end. But there is 2 Legal Livewires. One is for shorts, and one is for long form. I don't even do the shorts one at all anymore. Good morning, Mac. How are you today? Good to see you. And my wife's channel, they're it's called Babes Breakdowns and Breakthroughs. They're not really doing anything anymore at the moment. We're trying to figure it out. But my wife and I are going to do some relationship shows. Because we were close to the end, and we fixed it. So we want to talk a little bit about that. Boy, look at that fan go. I guess we could watch let's see. Bing bong bonk. Let me find it. Yeah, this is good. This is good.
Where this is I swear to God under oath, that's what she said.
I never once said that, Your Honor. Under oath, I swear under oath, I
Step up,
never said
officer.
that.
Step up, officer. He heard it.
First of all, counsel, you do not direct my officer to
I'm
stand
sorry,
up.
Your Honor. I'm really angry now because we know where this
I'm
is.
really angry now.
I said, Your Honor, and I will repeat what I said. I said, I have text messages. He is in a swingers club, and that might be how you might know him, and that's might be how this might be laughable, but I will admit what I said. I have no shame in what I said.
A
because I was
defendant
upset
told that
because
to
I
the
feel like I'm
judge.
losing the case. So I'll admit what I said. I have no shame in it because I'm losing my life here right now. Because I know he's doing something illegal.
This is my
Welcome back to
channel.
Legal Livewire. Today we have an important update. Mr. Allen.
Welcome to the trial of the century. Well, at least in her mind.
Oh, I
Meet our
forgot
defendant, a self-proclaimed
Tommy's voice
victim, a
do the
relentless
intro.
warrior against imaginary
Oh, I gotta
foes,
take that
and the
out.
undisputed queen of courtroom chaos. She claims she's battling stage 4 cancer, but her medical
I
records tell
totally
a different
forgot
story.
about that.
She says the judge, shadowy cabal pulling has spiraled in much further than does known. It's a masterclass. The court isn't here for theatrics.
Damn, I'm gonna have to
Less
remove
formal to
that.
see where we get. So, sir, please raise your right hand. Ma'am,
Damn
thank you.
it.
Do you both solemnly swear from the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
Okay. Now, I'm recording from my device here, so I'm going to need all of your voices to stay up, okay?
Yes, Your Honor.
I'm gonna have to go through. I think there's like 6 videos where he does the voiceover intro. Shit, that pisses me off, man. I forgot all about those.
Yes, Your Honor.
So I wanted to state one thing is that my court officer informed me that he knows your
Yeah,
client,
I
counsel.
know.
I didn't inquire as to how he knows him, but I will say that I don't know I don't believe that affects my ability to be unbiased. But I wanted to place that on the record in case anybody had any questions that they wanted to ask, or if they wanted this court to disqualify itself.
I do. If I might want this to be brought down to Wayne County,
Well, it wouldn't be Wayne County, it would be another district court.
then yes, it might be. If it's not gonna be dismissed off of the motion to dismiss, then I do want it brought to a different court.
Okay, on what basis, ma'am?
I already know he's told me in the past that he has the judge in his pocket and the police officers in his pocket. I have a box of text messages saying that to me.
Okay, so let me just clarify one thing. Sir, do I know you?
No, ma'am.
He's been in front of you many of times, and I have.
Hold on,
records of that.
ma'am, hold
Yes.
on just a moment. You made an allegation, so I want to clarify that for the record, because I don't know that I know Mr. Branson.
Yes.
I thought she was pointing at me, Your Honor. I didn't realize she was pointing at Mr. Branson.
No, Mr. Branson.
Okay, so, sir, have you been in front of the court before?
No, ma'am. Well,
Have you been in front of this court before?
Yes, I'm gonna say 20-some years ago.
So it would not have been in front of me.
No.
It was not in front of me.
Yeah.
When you were a member of the city council,
Was I a member of the city council?
you signed off papers on him to do side work, and he actually submitted that, and you were the one who signed off for him to do property work on his house.
Property work
Yes, he actually submitted that in his own evidence.
that I signed off for him to do
Yes.
maintenance on his.
Yes, Your Honor. I have copies of the paperwork. Would
Okay,
you-
let me take a look at that paperwork, because, I mean, if I. And Mr. Branson, how do you know my court officer?
A longtime family friend from years ago. I haven't had any
Well, I've seen
relationship
Santo right
for
there.
15.
Okay, so you know who each other, you know who each one is, but you haven't had any communication in the last 15 years?
No, easy, yeah, no.
If you go to his filing that he
Ma'am,
submitted
ma'am,
himself,
ma'am,
okay,
ma'am.
I'm just saying.
Please stop, just one moment, okay? All right. Let me take a look at that, please. Okay, so ma'am, this is zoning board of appeals and adjustment. I do not sit on this board. This is my husband who sits on this board. And I can 100% tell you that we do not discuss anything that he does here. This is definitely not me. I've never sat on a board, a zoning and appeals board. And this is from 2009, so I can tell you 100% that whatever this would have been, I have no idea. And I will also say that member DeSanto abstained. There were two members one that abstained, one that was absent. So I don't know why he would have abstained. I have no idea, but I can tell you that I did not sign off on anything.
Your Honor, I'm just going off of what he used to tell me, and then the text messages I have, where he said I have the judge in my back pocket.
Okay.
Your Honor, again. That's simple.
Hold on, let me clarify something. Sir, do you know my husband?
Personally, no.
Okay. So, ma'am, I will tell you right now, I do not know Mr. Branson.
Yes, okay.
So do you have any issues with this court continuing?
Not at this moment.
Okay, well, I would say that, that if something different comes up and it's shown that somehow I know Mr. Branson or somehow, then perhaps we can revisit it, but moving right at this point, I find that I can be unbiased.
Thank you.
And I don't know Mr. Branson, and Mr. Branson knows, my court officer, but they haven't had contact for at least 15 years.
Thank you, Your Honor.
So.
I appreciate that, Your Honor, for you being honest.
Okay, so and I will also say too, in smaller towns, right, you're gonna have that crossing and such, but, you know, as I learned in new judge school, that judges are elected to serve, and they have to sit and reside in the community that they serve, and so sometimes there's going to be people that they know, so it all just has to be disclosed on the record.
May I just be frank a moment? I'm just scared because in my text messages, since I've lived there, he has said he has police officers in his pocket. He has a judge in his pocket. That is just where it's at.
Let me see the text message you're referencing, please.
No, I will find it. I have 2 full boxes that I've printed out.
Okay, I'd like to see that.
I will have to find them, but.
Okay, I'll give you a moment, go ahead.
I don't know if it's in.
All right, James.
I pulled them up off my phone too. If it's not in the ones I printed off here, it might be in the ones that I.
Hey, Mac, I just subscribed 10 times. With all my different channels and things. So I think a few more other people did too. Man, my neck really hurts. I'm gonna have to go take some
I gave you.
And don't worry, I'm watching out for the
You're filing the motion?
Yeah, I have print off the entire text chain, but the police also have them too. Because we found out he wasn't a police officer. That he's never been a police officer, that he's told me, but we could continue, that's not neither here nor there.
Actually, no, Your Honor, she said she just represented under oath to the court. She made a statement, an affirmative statement about.
I just wish she could.
Ma'am, you can't interrupt.
Thank you.
Just one moment.
At this point in time, Your Honor, she's sworn under oath, and you've asked her for those documents, now she's backing away from it.
Oh, no, we're not stopping, I need those, I wanna see.
Okay, I'm trying to find them right now, I have stage 4 cancer, and I had a surgery, Your Honor.
I have stage 4 cancer, I had a surgery.
Okay.
I would like time. And if I can't
I'm
find,
giving you some time right now to look for those.
I have over 1,000 pages here, I'm just saying.
Okay, then do you have your phone with you?
Yes.
Okay, pull up your phone, and then on your text messages, when you pull it up.
May I sit down a moment?
Absolutely,
Thank
you
you.
can do a search, absolutely.
Thank
You can do a search for the name Pocket, or search.
I don't know
for
how
Pocket.
to do all that, ma'am. I have a 2010, an iPhone 10.
Actually, you can just go to your text messages, you can hit search, and you can just type in a word, and it'll pull up all the text messages that have that word in it.
The police are going through my phone because he has gotten into my phone, Your Honor. The police have, I have a police case against him right
Hold on,
now.
yeah, right now I'm not worried about that, I wanna know what that says.
He's been editing my phone, Your Honor, is what I'm trying to tell you.
Ma'am, please just take a minute, or 2, or 5, and look for that, please.
I will, but I'm just saying, I also
don't
made a motion to dismiss.
with no more commentary.
My motion to dismiss wasn't anything.
I said no more commentary. I haven't gotten that far yet. You've made an allegation and I want to see what that message is.
Judge, with your permission, can you grab some water for 1 second?
Some what?
Water. I've been sick and I'm dehydrated. I really need to drink some water.
Yes.
Thank you.
Just make sure you're not communicating with anybody out there, okay, please?
Oh,
No.
thank you.
You're welcome. If you have a bottle of water that you need to bring in, council, you can certainly do that.
I drank it on the way here. I lost like 8 pounds. Like my wife and I got nailed with this virus, and it's been a really rough road.
And did you do a search?
I am looking right now. It won't let me do a search. So I have to look through the entire text feed.
Do you know what month it was that he stated that to you?
When I first moved in.
Which was when?
Back in June.
Okay, so it's just going back to June?
Yeah, that's why I've been terrified living there.
Okay, ma'am, I didn't ask for all that. I'm just asking if you went back to June.
Yes, I'm all the way at the beginning of the text feed. That's why I said we can move on. I'm fine.
No, ma'am, we're not moving on until I see that.
I honestly, I'm not trying to lie to this court. It was said to me.
You made an allegation, and it's on the record, and so I would like to.
It is on the record because it was said.
Ma'am, I'm just gonna let you know right now. I'm not gonna have the continued interruptions. You made the comment on the record, the allegation on the record, so I want to address that on the record. That is what I'm saying.
I kind of grew up in a first responder household. My father was a firefighter in a local town. So
Here we go, guys.
We spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there. So
I want to take us back just a little bit. When you first became interested in training to be a first responder, did you share with us your first training was as an EMT?
Yes, sir.
Can you share a little bit with the jury what that entails?
So to become an EMT, there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
Is part of your work in learning to be an EMT, are you active in the field?
The initial training is, that's mostly classroom based, but once you sit your national written tests and you're
succeed through the, sir. At that point, did you decide you wanted more training? You want to proceed through the profession?
Yes, sir. So after a little while, I worked for about 1.5 years in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
Yes, paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat different patients.
As you worked through your training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic?
Yes, sir.
Does the Canton Police Department, in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department? Or Canton
I'm
Fire?
sorry, the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to remain employed by the Canton Fire Department, you have to become and maintain a paramedic certification.
So when you would go to work as a firefighter or paramedic, was it always the same, or did you get assigned as a firefighter one night and a paramedic a different night?
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So for example, if a fire call were to come in the town of Canton and I was assigned to ambulance 1 for the day, I would take all my equipment off ambulance 1 and I would transfer it to ladder 1. And then we would take ladder 1 to the fire call and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to ambulance 1. Then we take on the role as EMS. I take my paramedic skills and put them to work in the town on ambulance 1.
Let me ask you one more background question about how the Canton Fire Department works. When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically the engine of that district and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is everybody's in quarters and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022. I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning. So I left earlier than normal just to get in before the roadways got particularly difficult to travel and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton. The roads were starting to get. They weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have 3. We have 1 for fire, we have 1 for investigation, and we have 1 for EMS. The EMS tones went off and the lights came on. Whenever there's the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding, basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that
So
ambulance.
what did you do?
So I made the decision. I checked with the shift commander, and I jumped on ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What
And
happened?
just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance 1 in the patient compartment. The other 2 gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my Canton Fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But I just, on the way there, I just got in. I didn't know how their night had gone. So I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So in gathering all the equipment together, that can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe 1.5 feet by 1.5 feet to kind of peek up front. But again, I was so busy getting everything together, I really didn't notice, but I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors opened, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor. So 3 pieces of equipment with me. And I stepped out of the back of the side of the truck. There's a back compartment or a back door and a side door. I stepped out of the side door and I immediately noted the wind had picked up and the snow seemed to be heavier. And I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily. And it wasn't great all around.
Was it cold?
It was cold. Yes, sir.
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following sounds. I couldn't see anybody yet. So I just kind of followed the sounds. And then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton Police. And I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals and Canton Police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So that he was laying on his back. From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep. So I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. Like and just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
So after you touched his cold skin and you felt the carotid artery? Is that how you
Yes, sir. Carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. As I was checking that, the other 2 individuals on the ambulance came and met me, and they began doing the same thing just to check. I mean, sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the 3 individuals that were there, and just said, hey, I just have found no signs of life. We're going to see the next steps. And as I was saying that was when Anthony Flamati, who is the lead paramedic on this, made the decision. This is a workable cardiac arrest.
Let me ask you 2 questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter or paramedic Flamati's lead?
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter or paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is, you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
I want to ask you about a term you use. You said a hypothermic situation. As a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis. You're just saying it's a hypothermic situation because of why?
Just because of the conditions. He was extremely cold to the touch, and he was in the elements. We didn't know how long. So taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
Is there anything about Mr. O'Keefe's fingers or hands or his face that gave you any indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very.
Mean? I don't know. What does not perfused mean?
Sorry, there did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff, which can be signs of hypothermia and frostbite. And again, touching the neck. So typically when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamade called you back,
yep,
where did you go exactly?
So when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with a bag valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort?
Yes, sir.
A coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role?
Hey, Deanne, congratulations on day 2 of being alcohol free. That is amazing. Keep it up. We'll all be praying for you. And if you ever just need somewhere to spend your time, or if you ever need anything from us as a community, a lot of us are in recovery. I'm in recovery. Yeah, it's super awesome. We are so proud of you for real. And you got a good guy on your side with James Collins for sure. So yeah, keep up the good work. And yeah, if you ever feel like drinking, go ahead, get a hold of the show, email me. My email is in the description of the channel. It's Inside the Mind X, and just like in the subject line, put 911 or something. All right.
Role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which was myself in this situation, and then your cardiac and medication administration, which is, that would be Anthony Flamati, that would be Tony. Because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir. I was kneeling at his head.
While you were kneeling at his head, well, let me ask you more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes, sir. Very much. Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. That's typically the first questions that we ask. What medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? We kind of gives us something to go off of.
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up, when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And real quick, as I was in the process of providing ventilations, I said, do do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, with
the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson and or next to Mr. Jackson.
When you looked up and saw that person and asked about any background, what did she say to you?
I hit him.
Ooh, its voice cracks.
How clearly?
Oh, he's lying. Look at
saying.
Woo, where's our body language, guys?
I hit him.
I remember it very distinctly.
Yeah, no, you don't.
You've been to a lot of calls
you
over
don't.
the years and since.
That was
Yes, sir.
awesome.
Would you say hundreds or thousands?
Thousands.
Do you remember all?
Let's watch it again. I hit him. Oh, look, just right there. That's right before he said it. Look at him. Look, dude, tell me that is not the face of someone who's like, damn it, I'm going to have to lie right now. That's going to be my next thumbnail. Hold on. Let me just screenshot this. Oh, I'm so stoked about that. Just more proof. Isn't that awesome? Oh, geez. God, life is so cool.
What did she say to you?
I hit him.
I am.
How clearly do you remember?
See him
her
close his
words
eyes.
saying to you, I hit him. I hit him.
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yeah, he hates
Yes,
what
sir.
he's doing, but he's
Would you
doing
say
it.
hundreds or
Yep.
thousands?
That's
Thousands.
exactly what that
Do you
was.
remember all of them?
I
Yep.
remember aspects of
He hates it.
various calls, but not all of them. No.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting. I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit him, did you ask any follow-up questions?
I really didn't get a chance to, because following that, the individual just kind of walked away, or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Have you ever received any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any interest in detective work?
No, sir.
Do you have any interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical
Yeah, he's a bad liar
aspect
because
of a
he
cardiac arrest.
he probably
I really
doesn't lie.
I was stuck there. I couldn't get up and kind of
You know what I
follow
mean?
up on that at all. I was there doing that ventilation.
Is it your job to investigate cases or simply to get information to help treatment?
He's there to
Just
save
the
lives,
information.
not
When you
not
go out
lie
as
on
a
people.
firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get.
See how when he's explaining truth, his affect is much brighter. He's more animated, but his affect when he was lying was very flat, very like he just did not want to do it. But you know, he's a Boston guy. You know, if he was to not do it, you know, his whole family would shun him. You know, he's related, you know, 2 degrees away from the Albert, the guy who owned the cop that owned the place. Anyways, yeah, I feel sorry for him in a sense, but you know, you're lying, bro, and it sucks. It sucks. But I do feel for him. I can't not like the guy, you know, just because of, I don't know. I'm torn. That's all I got to say about that.
The patient up and onto the stretcher, and then
I
from
mean,
there we can move.
I am
from the stretcher
a
to the
police.
ambulance.
After you lift him
police
to the
officer.
stretcher, tell us what happens next.
So
The lie, please.
put Mr. O'Keefe on the scoop stretcher, and we were able to get him onto the stretcher itself, and then off to the ambulance. From there,
And I love what you guys are doing in the
maintained
chat,
my role
guys.
as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in. So I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway, so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could kind of hear it as you go to squeeze in breaths into the individual. You can kind of hear the secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck. We really
Suck
quickly
him.
suctioned him, and then we were able to intubate him successfully.
You say suck him or
to
suction him?
Definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm. He was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him. So every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues
When
are
he's on
stripping the
him,
clothes off him,
suctioning him,
is your
he had to
attention
squeeze
on
the bag.
clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity key aspect of airway management.
As you're doing that, do you notice what any of your colleagues are doing to help?
Like I said,
Bye, Wolfie.
they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But maintained, and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye?
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep, and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood, mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well, following intubation, and that was kind of there just to maintain his cervical spine.
See how he forgot that major thing about the head injury? I think what happens is that when he wants to get off the stand because he knows he's lied under oath, and so he's just thinking, I want to get off. I want to get off. Had he not lied, I feel like he just would have given all the information. Not that the head injury is a lie, but he had lied about the I hit him. And so he just wants to get off. And I think that's just more little signs of, in my eyes, because that's a big one. I mean, that's, he just said, oh, that's it. The only injuries I saw were, the arm and that. Yeah.
But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed off care to Good Samaritan Medical's physicians and ER nurses.
Let me guess. Karen Reed came running in and she was like, I hit him, guys. I killed him. Let me guess.
Able to give a report to the physician of just basic what we've done, what we've given for medications. In my case, what he was intubated with and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically he kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
Can't wait for the cross.
Told you that she hit him. Did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in perspective of your care? Okay. What role did that information play in your care after the defendant told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of.
Here's the deal. If that would have happened, he would have went in. They would have all went in there. The lead paramedic would have went in there, told the doctor, he was hit by an SUV, but they did not say that. When he just said that the lead paramedic goes in there and gives a big rundown of everything that's happening. And it's always like, how did this happen? He was hit by an SUV. Supposedly they had that information, but did they pass it on to the doctor? Was it in any report? That's a no, capital NO ×2 ×3.
Took it, noted it, and moved on with my aspect of the cardiac arrest.
Liar.
Have you had an opportunity at any point to see any video of that morning taken from any source, police car, dash cam?
Yes, sir.
All right, I'd like to introduce a video stream.
So this will be in evidence. There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
There's no objection.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2.
Defense ain't worried.
It is Cruiser 683 Stream 2. I'm going to ask to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m.
Well, looky there. Galen says, hey, Ed, after the bars, I'm hoping the judge will let Garrett from American Standard Dog on the dog bites. He is great and trained one of my dogs 7 years ago. Yeah, that is so cool, Galen. I love the connection that you have with these dogs all over the country. It's amazing. She's a rock star.
Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably those would be ambulance one.
Yeah, so not what you presume. Do you know what they are, sir?
And those are the lights for ambulance one.
Do you see the weather conditions as it's depicted on this video?
Yes, sir.
Oh, as you stood outside, was it same or different to how it appears in this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen, you'll see a straight item from the bottom halfway up the picture. Do you know what that item is?
I believe that's a flagpole, sir.
Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep, there they are.
Could you stop, please? Did you see the first person in line now behind the person with in front of the person with the blue hat?
I'm sorry, sir. Can you back it up like 10 seconds?
Certainly. Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Could you stop, please? After informing you return, is that after firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Okay. Please continue. Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, I hit him, I hit him, I hit him?
It was right there, sir.
Could you continue, please? Could you stop for a moment? There's no voices or noises from people coming through that audio. When you were there that night throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
They're not picked up on the audio?
No, sir.
Please continue. Sir, are you still at the flagpole?
Yes, sir. I'm kneeling at the head of the patient.
Just awful, man. Poor guy. Another thing that's really disingenuous from the prosecution is that they can't have it both ways. They can't have it. Yes, she admitted to hitting him on Dateline, of knowing it that night and seeing him out there and leaving the scene of the accident. But then also her here in the morning freaking out, just having found out that he was dead on the side of the curb. And even if she did say that, I hit him, which she didn't. And I think at the very best, she might have said, "Did I hit him? Did I hit him?" Because that was right where she was parked the night before. And that's a perfectly logical explanation for saying that. I mean, that's what any one of us would have said, like, what? How is he dead here? Did I hit him? You know, so yeah. But let's just keep going.
Are you included in that group of first responders?
I am not, sir. I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you. We can conclude the viewing. With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes.
Thank you. May I approach?
Yes.
Thank you.
The judge knows too. She knows.
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach again, Your Honor?
Yes.
I'll be right back, guys. I gotta hit the little girl's room real quick. TMI.
May we publish to the jury?
Yes.
We get tell it to the jury.
Is that the photograph you just identified on the screen?
Yes, sir.
Showing you a second photograph, I'd like to ask you some questions about it.
Can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman.
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
No.
Okay, yes.
Thank you.
Thank you.
With the court's permission, could I publish exhibit 2?
Yes.
And sir, that's what you recognize as the area where you were helping to treat John O'Keefe?
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
If we could take down that exhibit 2, Ms. Gilman. May I approach, Your Honor?
Yes.
I would move to introduce this as exhibit 3.
All right.
Check.
For the court's permission, I'd like to publish exhibit 3.
Sure.
Sure. Boy, that's a lot of accent there today.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down. Thank you. Thank you, sir. I have no further questions, Your Honor.
All right. Jackson?
Let's dance. You ever dance with the devil in the pale moonlight? You're about to. No, James, I have a tattoo at 1 o'clock, so kind of sucks, or else I would. Get him, Jackson. Get him. This is exciting.
Thank you, Your Honor. May I?
Yes, please.
May I beat this guy to shreds right now?
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning,
Respect.
How many
Respect.
conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame within the last 3 weeks, within the last 3 months, last 3 days.
Within the last 3 weeks, I believe one the week after that, and then one last night.
One
Last night.
Last night. What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No. No, sir.
Male, female?
One female, one, I believe, state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully?
Yes, sir.
Whom you've met with several times, correct?
Prior to that, I believe only once or twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings.
You knew who he was, buddy.
Mr. Brennan.
Okay.
But beyond that, I can't speak to.
What did y'all discuss 3
Be
weeks
honest,
ago?
man.
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony and in that sort of realm.
Prior to today, how many times have you testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once last year.
All right. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year?
No, sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay. But you just saw that, or you just read that and went over that 3 weeks ago.
I believe so, sir. Yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him.
So previously testified possibly to 2, but it was 3.
Okay. Your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now as you sit here that it was 3 times you heard that than it was a year ago when you testified that it was 2 times?
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You then met about a week after that, which would be 2 weeks ago.
That would make you a unicorn.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony. And that was really the gist of it.
And tell me the specifics of the prior testimony that you...
Again, it was the how many times we had talked about saying I hit him. Again, it was 3 times. And then there was also the video that was just played for me.
If I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
I'm not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to, he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way, correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that firefighter Nuttall is inconsistent with your testimony today, correct? You
Yes,
agree
sir.
with that?
But that is how it went that morning, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
yes, sir,
that you heard the phrase twice, and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. And you
No.
say not to my knowledge, meaning?
No, sir, we did not.
Okay. So it was just about the number of times that you heard the phrase.
That's right. Lock
I hit
them in.
him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that, I mean,
lying.
It was 3 times, and that we were continuously making sure that everything was the way that it had happened that morning.
That was a
Everything
fabricate
was the way that
pause.
Mr. Brennan wanted it to be.
No, sir. The way that it was I remember it, and I recall it happening.
Okay. So he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later or met with you a week later and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Just a second. May I have just a moment, Your Honor?
Yes.
Okay. And when you talked last night, did you assure Mr. Brennan, nope, nope, nope. When we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times.
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him, I hit him, I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video?
No, sir.
Just the clip that we saw?
Yes, sir.
Okay. What did y'all talk about in relation to that video?
Mostly nailing down who was who in that video.
Okay.
Being the other personnel on scene, where I was, and that was about it.
He showed you the clip that you showed. He showed you the clip that you just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, I hit him?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
Yes, sir.
And you defined, that's the point at which she said, I hit him, I hit him, I hit him.
Yes, sir.
And that's in response to your question. I want to make sure I'm clear about this. You asked, do you know him?
Yes, sir.
And she repeated the phrase 3 times, I hit him, I hit him, I hit him.
Correct.
Okay. We'll talk more about that in just a second. Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right. Not a trick question. My question is much more simple. You were able to establish after 3.5 years now, exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay. You testified last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
That could be done you said in the ambulance, it could be done in the hospital, it could be done in situ out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
It's not really a lot of care taken to preserve the clothing from an evidentiary standpoint in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up in the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever.
Mm-hmm.
Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at a grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes.
That night that you responded?
It was.
We just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could.
I am watching his body movement like a hog. He's just doing all kinds of little. He's starting to getting a little twitchy. His affect is super guarded. Anyways, yeah, it's going to be amazing. Hey, Mac, do you maybe want to come on with me tomorrow if you're up early? I will hit you up this afternoon. We'll talk about it. Just something for you to think about. I wish I'd have thought about it today, but I'm almost done, and I'm going to go tattoo this afternoon.
Assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove or somebody had to remove in order for him to be properly assessed.
I did testify that way. Yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact
And we can
question,
stream
didn't
to
I?
both
And
channels.
I
To
said, your memory of him having
new
that big
channel
puffy coat
and-
on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case.
Yes,
Hey,
sir.
Deb.
About that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just the I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Got it.
There's nothing you can do, man. You just got
The
to
fact is,
agree.
well, let me ask you a different question. Did Mr. Brennan tell you what Mr. O'Keefe was actually wearing?
No, sir. Actually, I believe you did.
Last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Wasn't wearing a hat.
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
This is perfect. He's going to impeach him on the testimony about what he was wearing, and if you can't even remember that, or you made it up or whatever, I hit him is you just don't know anything, young man.
And obviously goes without saying, but I'm going to ask it anyway. That's not being appropriately dressed for the winter.
No, sir.
Don't even. Come on, man.
You indicated that you did notice
I'm the
certain injuries on
testimony
Mr.
police.
O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay.
Exactly.
the majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it, over his right eye, often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
They're right arm.
Biceps.
Right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right,
Got it.
right about in there.
Okay. And what did the scratches look like?
They were deep. They infamously referred to them as far
So
as
deep.
but they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material.
Mm-hmm.
Is that yes?
Yes, sir.
Which
And
is not
were they
on the
parallel?
taillight chunks.
Meaning they were going in the same direction?
Yes.
Were there any scratches below the elbow?
There were. Yes, there were. They were not as significant as the ones on the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they looked like scratches to you. That's how you described them.
They did.
There would be DNA all over everything, man.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you,
Okay.
sir. It was just kind of how I quantified it in my mind.
Okay. But what you did was you did this motion.
Yes, sir.
As you said, there were furrows. And remember,
I'm
there was
surprised the judge is letting
an
that.
embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent, right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it was consistent with a physical altercation as well.
Excuse me?
Objection to referring
Leading.
to past testimony before a question is asked.
So
Yep.
sustained.
Yep.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Sustained.
What are some of the causes of lacerations?
You can get a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Can you answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute, please.
Yeah, I already know what she's gonna say, guys. She's gonna just tell them like, look, you're bringing a lot of things in from the previous trial as evidence. I'm surprised she's let it go on this far. You can, to help impeach, you can do that, but he's actually bringing in mishaps from the previous trial into this trial as evidence, and that's like, I'm no lawyer, but I've been to enough trials. I've been on the receiving end of enough trials, and you guys also know I've also an expert witness for a law firm here in town with gangs and things like that, and so I've been involved in murder trials as a witness expert, giving expert testimony, and I'm almost positive that is what is going to be said. And this poor woman here, man, she just wants truth and justice. That's Mr. O'Keefe's mom. And it's just too bad. She just hates Karen Reed. And if Karen Reed was guilty, I'd be like, yeah, I'd hate her too. But she really isn't, guys. Right. If it's a deviation, exactly right, Perfectitis. If it's a deviation, then yeah, I feel like it could be mentioned. I know there is a rule, and that I've heard before, is that using an exorbitant amount for evidence, they can't. I said it better the first time because now I'm Sam-splaining it. Trying to Sam-splain some shit. Hey, you guys all need to go watch the Gemstones on, I think it's HBO. It is hands down one of the best shows I've ever seen. The writing in it is amazing. It's amazing. I don't know why I just segued into that, but I did. Yikes.
Mr. Nettle, we are going to let you take a break with the applicants after the lunch break. So this is
Sounds good.
The lunch break. There's lunch here for you. I assume Tony is again.
Yep, there we go, guys. It's lunch
here for you.
break.
We'll see you in about a half an hour.
I wish I could stay.
All rise, please. Leave your notebooks in your chairs.
I am the Righteous Gemstones. I did try to get out of my tattoo this afternoon. They're not letting me. They have places to go. I tried to reschedule it, but yeah. So yeah, guys, it's pretty good so far. I'm thoroughly enjoying it. Happy Toots Day. It is Toots Day. Happy Toots Day, guys. And I guess that's it for today. I will see you guys tomorrow if I don't come back in this afternoon, which I might. I might stop back in this afternoon. We'll just wait and see. Make sure you have your notifications turned on for After the Bars so you get all notifications. I appreciate it. Please hit the like button so the next time we do one of these, it helps me get into the algorithm. If you guys could all please smash the like button, I really, really appreciate it. You guys are awesome and amazing, and I love you guys so much. Thanks for hanging out with me this morning. I will see you same bat time, same bat place tomorrow for more coverage. I might tonight do that show on Carmelo Anthony and what he's to expect when he gets to prison. It's not good. It's not good. And yeah, so maybe look out for that tonight. And I think that's about it. Again, thanks for coming out. I appreciate you guys. You guys are all great and amazing for participating in the chat, giving young Deanna some support on her new recovery mission. I think that's amazing. I didn't read all the comments that was that you guys, all the conversation that you guys were having. I'm going to try to go back and watch some of that later, or read some of that later. So again, you guys have a wonderful evening. Try to help someone improve their life today, even if it's just like helping them with some groceries at the store, or, you know, whatever. If you see an opportunity to help improve someone's life today, take advantage of that opportunity, because we don't get them all the time. And I promise you'll feel a lot better after you do.
Stay loud. Don't be woke. Stay wild. Stay awake.